impressive and important briefing from the Justice Policy Institute, which highlighted the fact that Maryland incarcerated a higher percentage of African Americans than any other state in the nation, and that was something that was used as a point of reflection and discussion throughout, even through the campaign that we just wrapped up, but also through the policymaking spaces in the halls of Annapolis. And so that report was so impactful that we thought we'd have Justice Policy back because it was so enlightening. And obviously, today's briefing is going to be on the parole in Maryland. So it's a comprehensive deep dive on all aspects of parole in the state of Maryland. And obviously, in the last 3 or 4 years, we've had some very important discussions and debates on how to change our parole system to make it so we have ultimately better outcomes in our system. So today, we're just very honored to have you here. Thank you all for coming and joining us and sharing your findings with us. Today, on the first panel, we have Ryan King, the Director of Research and Policy. We have Keith Wallington and Shanika Braveheart. And then we have Willie Hamilton, who will be here as well, all of whom will provide, kind of walk us through the presentation and the report. And then in the back, we have Stanley Mitchell. Willie, you're going to be here for questions as well. Gwendolyn Levy, and then Etta Myers, who are not going to be presenting, but are available for questions afterwards once we move into the Q&A session. So without further ado, I'll turn it over to Keith. Mr. Wallington, you want to go first, or we'll start off with the presentation? So welcome. Thank you for briefing us.
Absolutely. This world is not designed for left-handed people and people that are 6'6". We'll make it work. All right. Thank you, Mr. Chair, Mr. Vice Chair, and members of the committee for this really important opportunity to come here and share with you highlights from a very kind of 30,000-foot view and then also a very deep dive into the Maryland parole system. My name is Keith Wallington, and I am with the Justice Policy Institute. JPI is a national nonprofit organization dedicated to workable solutions to problems plaguing juvenile and criminal justice systems. Although we're a national organization, we've done quite a bit of work here in Maryland. We focused on Maryland for about the last 20 years with about 25 reports to show. Joining me today are my colleagues, Shakina Braveheart, Troy Berner, who is not quite with us yet, Ryan King, and Mark Schindler. And then with us, we have our invaluable impacted partners with lived experience, Ms. Gwendolyn Levi and Ms. Etta Myers of the Maryland Justice Project, and Out for Justice, Stanley Mitchell and Willie Hamilton of No Struggle, No Success. A deep examination of the Maryland parole system is way overdue. As you will hear next from my colleague, it's been unimaginably too long since Maryland has commissioned a study of a system that consumes so many of our resources. We hope that this deep analysis will provide the data and information for the General Assembly to pinpoint where reforms are needed to correct a system that has severely veered off course and free up resources for other needed investments. One of the consequences of Maryland's broken parole system is how it has exacerbated racial disparities in the state that are, as Senator Chairman Smith already mentioned in a report JPI put out a couple years ago, show that Maryland already leads the country in racial disparities in the justice system. Maryland has the worst racial disparities in the justice system than any other country, any other state in the country. And it is seen in parole. As recently as 2018, more than 70% of Maryland's prison population was black, compared to just 31% of the state population. The data from the Department of Justice show that the proportion of the Maryland prison population that is black more than double the national average of 32%. These disparities are rooted in decades of unbalanced policies that disproportionately over-police under-resourced communities of color and a criminal justice system focused on punitive sentencing. The racial disparities in parole decision-making are a result of the racial disparities throughout the entire system, and they are profound. On average, the Maryland Parole Commission's hearing portfolio was 69% black and 27% white. Between 2017 and 2021, Maryland processed 4,449 revocations of parole among those individuals released from a state correctional facility. Like other data discussed prior, about 2/3 of parole revocations were for black individuals, with whites comprising 32%. The racial disparities, again, I want to make this point, the racial disparities that we see in the parole decision-making are not a result of, the racial disparities we see in parole decision-making are a result of the overall disparities in the system that rears itself in parole. The data shows that the parole board itself does not promote racial disparities. Their work is simply a result or representation of the racial disparities that are already in the system. When examining the racial and ethnic composition of grant rates between 2017 and 2021, black individuals averaged 68% of the grants, aligning with 68% of the cases heard. Maryland has living examples of how a better parole system could actually improve public safety. We have seen the success of the UNGERs and more recently the JRE recipients as proof that we can safely lead parole reforms. Not only have the UNGERs showed Maryland that we can safely reform parole, but they're a unique case study for the entire country. Our partners here today with lived experience, each are playing invaluable roles leading their respective programs. Ms. Myers, Ms. Levi, Mr. Hamilton, and Mr. Mitchell are each an example of how parole could be thought of in the same way of promoting other initiatives that create public safety. Through their programs, they touch and redirect so many justice-involved or would-be justice-involved people, especially youth and emerging adults. Hopefully you will engage them about some of the issues we're discussing from their lived perspectives today, then just as importantly, engage them about some of the absolutely amazing things they're doing since their own experiences with parole. Now I'm going to turn over to Ryan King, JPI's Director of Research and Policy and the author of the report. Ryan is going to share highlights from the report. Then following Ryan, we will have Shakina Braveheart and then Mr. Willie Hamilton, who will articulate why we need parole reform from the examples of lived experiences. From there, I would encourage the committee to engage our partners with lived experience so you can hear about some of the wonderful things that they're doing since coming home. Thank you so much again, Mr. Chairman, for having us. And with that, I'll turn over to Ryan.
I actually fixed this really quickly. I'm so sorry.
Oh, I didn't break it yet.
No. It's we've changed our system. And everything has to be through Zoom.
Thank you, sir. Crash the system.
It's always slowest when everybody's watching.
I know, right? At least you can see it's slow and it's not
Now you have to remember your password.
I will.
Now it's got to install you out there.
Right.
That's how it goes.
First day. share screen, and we'll do it from there. Sorry, okay, there you go.
Good.
Yeah.
Thank you, Mr. Vice Chair, and I don't know if Mr. Senator Smith left. We'll be back, and other members of the committee for the opportunity to come and speak with you all this afternoon about the Maryland parole system. It's been a project we've been working on for a while and a long time coming, and we're really excited to sort of start this conversation and think it's a terrific way to begin the 2023 JPR session. As Keith mentioned, it's been a while. In January of 1935, an organization called the Baltimore Criminal Justice Commission released a report called The Study of Parole in Maryland. It was the first, and to our knowledge, the last comprehensive look at parole release decision-making and supervision in Maryland. And in reviewing this, sadly, 90 years later, many of the concerns that were flagged in that report remain as issues and concerns now. The authors noted that parole is widely misunderstood, and that it was really critical for laws and regulations to examine parole practice, as there is, in the quote, a very wide difference between parole in theory and parole in fact. And so that's one piece I want people to think about as we talk about sort of what the policies are, and then what we've heard, kind of the ground truth about what actually happens in practice and how it affects people's lives. The report flagged both high recidivism rates and racial disparity as two indicators of the problematic parole system. Again, should be familiar to anybody who follows criminal justice. And they also noted that parole, as operating in 1935, made a, quote, poor showing because, quote, untrained, overworked, and underpaid people, many of whom were appointed for political purposes, struggle to do a job requiring unusual skill, techniques, and training. So in many ways, they connected the public dissatisfaction that people were experiencing with parole all the way back in 1935 due to really a misunderstanding about what the purpose of parole was, and also in terms of actually staffing and hiring people to be able to meet those goals. And so obviously these shortcomings are driving what we see in recidivism and also undermine public trust in parole. So 2 years later, or 80, what, I'm going to do math on the fly here. Since 1935, we decided, we would like to take another look. And this came out of work, actually, the Justice Policy Institute did in the District of Columbia, where we worked to do a real soup to nuts report on parole in the District of Columbia. And what was really terrific about that is it gave us an opportunity to really do a deep dive into best practices. We talked to national experts, technical assistance providers, folks who work in parole in different states, reviewed research, went to conferences to really pull together a set of what we felt were, or what the field, I should say, has identified as best practices in parole, and issued that report in the district. And obviously, those best practices are portable to other states. And so it's an opportunity for us to do something similar here in Maryland. And what's unique about this report that will be forthcoming is that we've got really terrific, and I just want to compliment and thank the Department of Public Safety and Correctional Services and the Maryland Parole Commission, and in particular Angelina Guarino, who were tremendously helpful in providing data and support as we went through. So one of the big things that we're able to present in here are a really deeper dive into parole practice with data, which is the first time in many ways that those data have been available. And I think, as we all know, right, the first step in really understanding impacts is to be able to look at data. So it was a really terrific, they were terrific partners and gave us a really great set of data that's sort of formed the foundation of this report. We also talked to a number of individuals, attorneys, advocates, as well as individuals who have lived experience in the parole system to get their perspective on parole, and all of that is in the report. And I'm going to take a little bit of my time here just to kind of hit through some major recommendations. I know that the Maryland Parole Commission will be providing a lot of the same data, so I'm not going to be redundant in there, but I want to hit on some main pieces that we think stick out, that are really highlight important policy issues that I'd like to put on your radar, and then a handful of the recommendations that we think are also critically important, just to have a conversation and hopefully to drive future work in this space. So just to kick off, the Maryland Parole Commission has released decision-making authority for individuals sentenced for longer than 6 months who served at least 1/4 of their term, sort of writ large. And again, I'm sure that the Maryland Parole Commission representatives will dive in more deeply. But To overgeneralize, eligibility is determined by several factors, which can include the type of crime, the length of sentence, the number of times an individual was convicted of a crime, the number of sentences being served, and the sentencing judge's discretion. There's a whole host of different factors that ultimately determine parole eligibility. So starting with the eligibility question, we received data going back to 2017 from the Parole Commission. And since 2017, the number of newly eligible individuals, and sort of key important part here is newly eligible, meaning these numbers that I share are people who are newly eligible that year. There are people that obviously go through, but these numbers are people who are going through, newly eligible individuals, was at 1,115 in 2017. And that's declined now to 587 as of year-end 2021. A lot of that decline is attributable to the shrinking incarcerated population and the impacts of COVID-19. The decline between 2017 and 2021 was primarily driven by a 93% decrease in emerging adults. So those are individuals 25 years of age and under, so 18 to 25. So most of that was driven by a far fewer number of those individuals becoming eligible. And this decline coincides with a current trend in the sentenced population as well. In 2017, 23% of all individuals newly eligible for parole were between the ages of 26 and 30. And 6 and 10 were 35 years old or younger, so basically up to 35. By 2021, more than 4 individuals were 35, more than 4 in 10 individuals, newly eligible individuals, were 35 years of age, while those 41 years and old and above increased from 27 to 43%. So that's a lot of numbers. Main point being, we're seeing an older, graying population among individuals who are newly eligible. And perhaps not surprising, as the population shrinks, you might think that the population left behind might be people who've served longer sentences and are thus older. Those over the age of 60 more than tripled to 8% of the newly eligible population. Again, contributing to sort of a graying of the Maryland prison and parole population. The next piece in eligibility is notification. I wanted to talk quickly about notification. When an individual is eligible for parole, the Maryland Parole Commission must provide a 15-day written notice of the date, the time, and the place of the hearing, unless there's good cause. So while the regulations, COMAR regulations, outline a timely notice system, the practice itself we found is inconsistent. The Parole Commission delegates the task of notifying individuals to case managers who are often overworked with high caseloads. And based on interviews with individuals seeking parole and their advocates, we've heard that it's not uncommon for case managers to inform individuals as much as the day before or the same day as their hearing. So the notification question is one that I want to flag. It's an important one, and as you'll hear from other folks who've joined us today, can give a sense about why notification is so critically important, why advance notice is so critically important to prepare for one's parole hearing. Prior to the hearing, the Maryland Parole Commission gets a written report from the case manager that summarizes factors meant to determine the likelihood of successful reentry, such as recommendation by institutional staff and a projected date of mandatory release. And that completed material is due back to the Parole Commission within 60 days. Maryland law does not mandate a risk assessment for parole consideration, except only for individuals who are serving life sentences. And so this is another piece that I want to flag, which is critically important. So the risk assessments of those serving life sentences consist of a psychological exam, an IQ test, and an evaluation in accordance with an instrument called the HCR 20, which is a 20-item risk assessment. It considers factors drawn from 3 categories, both historical, clinical assessment, and risk management. So historical factors focus on past events, experiences, and psychiatric conditions. Clinical assessment attempts to uncover any negative attitudes toward the future. And risk management looks at the feasibility of reentry and any necessary supports for successful release, as well as potential stressors that could lead to future criminal offending. The issue that we want to flag is that because the risk process is labor-intensive and inefficient, a risk assessment can often delay the parole process by up to 2 years. An individual serving a life sentence can only move forward after receiving clearance following the risk assessment. So this is another critical area that we heard from people we spoke with, is that the process of going through for individuals who serve life sentence for parole review is particularly difficult, and the risk assessment piece seems to be a real hang-up in that space. Moving on into hearings. So there are 2 types of parole hearings, those held by hearing examiners and those held by parole commissioners. The commissioners only hear cases when an incarcerated individual is serving a life sentence or there was a loss of life involved in the offense. In addition, parole commissioners are present at open hearings, and while hearing examiners hear the other cases. So in 2018, the Parole Commission heard 5,000 cases, which was an increase of 76% from the prior year, so a significant increase, and that's attributable largely to some of the sentencing modifications in the Justice Reinvestment Act that had taken effect in fiscal year 2018. This increase occurred despite an 8% decline in the number of newly eligible individuals that year, so a lot more people were getting reviews. And since then, there's been a steady decline. So as I said, it went in 2017 from about 2,834 to 5,002. By 2021, we were back down to 2,023. So a lot of those individuals have been processed and moved through in the hearing, through the hearing process. Obviously, some of that drop also is attributable to court closures and the COVID-19 epidemic. Just under 6 in 10 individuals who received a parole hearing during this period were 35 years old or younger. Less than 1 in 5 were emerging adults, and people 51 years or older comprised nearly 1 in 8 parole hearings. Moving on to the final decisions, parole commission decisions are rendered after considering a whole list of statutorily required criteria. Some of those factors include circumstances of the crime, physical, mental, moral qualifications of the individual, progress while incarcerated, risk of reoffending, impact statements from the victim, judicial recommendations at the time of sentencing, and other factors. So they are laid out in statute, but the law itself does not specify how the Parole Commission should weigh these factors. And what we've seen time and time again and heard from people with whom we spoke was that this often means that there tends to be, in essence, sort of a review of the circumstances of the underlying offense, and a lot of time spent talking about the original crime that an individual was sentenced to, which may have been 10, 20, 30, or more years ago. And in many ways, that becomes sort of the single most heavily weighted factor, more so than personal growth, program completion, or disciplinary record while incarcerated. So this, we think this is a serious issue. We'll talk a little bit more about it when we get into the recommendation section. Consistent with the number of parole hearings trends, the number of people requesting, the number of parole requests granted spiked in 2018. So there was a lot more people that were that had hearings, and significantly, I think, as a result of the Justice Reinvestment Act, a significant number of people the grant rate went up and then went back down again. So in 2021, the grant rate is about 38.8%. So one thing I wanted to flag was, surprisingly, the parole grant rate decreased between 2020 and 2021, despite the emergence of COVID-19 in early 2020. And so I think a lot of folks know that in many states, parole was a mechanism used to get people out of prison, both to reduce the spread of the virus. And so a lot of states would expedite parole release. Individuals would maybe let out 3, 6, 9 months early. There's a whole bunch of different processes. But in most cases, you would expect to see that increase. But in fact, we see in Maryland that the parole grant rate decreased between 2020 and 2021. So that's, we think, says that there are clearly some issues there, particularly at a time when you would have expected probably to see parole grant rates increase. Grant rates in Maryland follow a bell curve. Emerging adults have a grant rate of about 37%. It increases to about 43% for folks 31 to 35, and then decreases sharply. People over 60 are paroled at a rate of about 28%. And so parole grant rates that decline with age, I think it's many of you probably know, run counter to everything we know about criminal offending patterns. Crime is a young person's endeavor. Rates of recidivism and criminal reoffending drop precipitously after the age of 40. And so in many cases, the individuals that are at the lowest risk of reoffending actually have some of the lowest parole grant rates. And I think that ties back to the earlier point, which is the circumstances of the crime piece playing such an important role in the parole release decision, because these tend to be a lot of individuals who have been convicted of very serious crimes that are older and have served very long terms to that point, but have also, in many cases, have had exemplary conduct while incarcerated and have served a significant portion, as we said, decades of time incarcerated. And so I'm going to shift to recommendations and run through a handful of the best practices that I'd like to just put on your radar over here. So the first one I've mentioned a couple times is we believe that parole boards should operate under the presumption that the goals of punishment have been met at the time of initial parole eligibility. And parole release decision-making should be based solely on objective factors related to an individual's future risk to the community. The underlying circumstances of the crime were adjudicated during the court hearing and at sentencing, And the law has said that at the time of initial parole eligibility, those goals of punishment should be seen as having been met, and that any decision about whether a person should be released should be based upon what that individual has done from when they were entered prison until that time. As I've said, in many cases, the parole board makes decisions based on its determination as to whether the original sentence was, quote, enough based on the committing offense, and too often the discretion is used to re-examining the sentencing decision, and in many ways usurping the authority of the judge. In practice, the severity of the offenses tends to overwhelm all other considerations. It's probably the single most important factor. Now, this is, in some states, this is actually on the books, that the goals of punishment should be presumed to have been met at the initial time of parole eligibility. But even in those states, in practice, it often doesn't happen. So this is something that requires a lot of oversight and a lot of attention. Second best practice is that the parole board should have transparent rules and procedures that reflect all interested parties' input. It is indefensibly confusing, the parole process. It's very hard for individuals who are in it. It's hard for folks who study it, and it can even be hard for family members and others. The deliberations and criteria that guide release decisions are often cloaked in secrecy, and this in turn sort of fuels concerns from individuals, both the public as well as people going through the parole process, about the legitimacy of the entire process and whether the decisions themselves are largely arbitrary. It also hampers effective oversight, because if you don't have those transparent rules, it's very hard to see how performance is going, and how whether you can hold a parole commission accountable for their rulings, and whether there's consistency in their rulings. Third best practice is reasons for denial of parole should be documented in writing and appealable. Currently now it's often just a couple of sentences, and we believe that for the purposes, again, of accountability and transparency, should be a detailed description as to why an individual was denied parole, if they were denied parole, what those reasons were, and then importantly, they should use the hearing as an opportunity both to either reward an individual for demonstrating transformative change, or as a tool to motivate an individual to take additional action before they come back for another parole hearing. And if these individuals are getting 2 or 3 sentences that say, the details of the crime were particularly horrific, and this person's done good stuff, but we still think they need to spend more time, that doesn't really map out a plan for an individual. They should have an actionable plan, which again, the transparency piece and the predictability piece as well. Another best practice, paroling authorities should expand eligibility and develop standards for compassionate release. We mentioned a lot of older individuals serving very long prison terms in Maryland prisons. An end-of-life assessment should not solely be determining condition for an applicant's release. So in many cases where in Maryland right now, we're literally talking about individuals that are expected to die in a matter of days after being released, and we think that's far too stringent criteria. We think that there are better ways to evaluate prognosis and give people opportunities to move out of prison and live their remaining days in a different setting. Data-wise, 6% of the Maryland prison population are over 50, and there's another 2,341 people serving a life sentence. So we've got a lot of people who are older and a lot of people that are serving very long prison terms. So this is going to be a continually growing issue that the state, like many other states, will have to face. Another best practice is the Maryland Parole Commission must work closely with other criminal justice agencies as well as support agencies to ensure that the development of a parole release plan supports successful reentry. So this is a really detailed transitional plan, an actionable transitional plan, and we need to ensure that when individuals come out of prison or in the community, that the resources and supports, housing, job training, whatever may be necessary, are available for them. It is a real problem in Maryland. It's a real problem everywhere with folks coming out, and obviously has significant implications for recidivism and rates of reoffending. And then lastly, what I think this may seem like not at the core, but I think incredibly important, is to establish inclusive standards for parole board member eligibility, including education and work-life experience. So we think that right now the Maryland Parole Commission, like many, is heavily skewed toward backgrounds in corrections or law enforcement. This comes at the expense of other important representation, such as people with a social work background, practitioners who provide reentry service, those individuals with valuable lived experience, And we've seen New York State as an example of how having a more diverse parole commission with different training, different experiences to bring to bear on the release decision-making process can have tremendously positive results. New York changed out a couple of parole commission members and saw significant increases in grant rates without sort of any commensurate increases in crime. So those are sort of the general overview of our report. I don't know if we're going to do questions at a later time, so maybe I'll pass it over to Shakeen. I just want to thank you again. The report itself, we're hoping to probably get out later this month or early February. You see a much deeper dive into all of what I've really just sort of scratched the surface here. But I really look forward to you having the opportunity to review it, because I think we tried to make it very, very clear and actionable for the legislature. So there are, we hope, ideas and opportunities in there for your work to really improve Maryland's parole practice.
Thanks, Mr. King. Just as a thing, I know we were having trouble getting your presentation up. Does your presentation have those top lines that the numbers and the statistics?
That's a different presentation,
oh, it's a different one.
But I can share those.
Could you please? Because
I actually think the Parole Commission, I looked at the Parole Commission, a lot of those are in there, but I can share with you top lines as well.
Okay, thank you.
Good afternoon, Chairman Smith, Vice Chair, and ladies and gentlemen of the committee. I am Shekina Braveheart, Advocacy Associate with the Justice Policy Institute, and I've also come in contact with the criminal justice system myself. Much of the data contained in the report did not come as a surprise to impacted folks like myself. We already knew, just by firsthand experience, personal experience, or from our peers, how things play out. We know that parole grant rates decline with age. We know that parole grant rates decline as time served increases. And as Ryan mentioned earlier, we recognize that it likely reflects the focus on the underlying offense, especially when people have crimes of violence, and among individuals serving these long sentences much into their geriatric years. During parole hearings, the primary focus is on the one thing that we can't change, right? The circumstances of the offense, because that's static. And it weighs more heavily, unfortunately, than things like personal growth, rehabilitation, program completion, education, things like that. So that's why today I wanted to focus on best practice recommendation number one. Best practice recommendation. The parole board should operate under the presumption that the goals of punishment have been met at the time of initial parole eligibility. And parole release decision-making should be based solely on objective factors related to an individual's future risk to the community. To do otherwise really goes against the spirit and intent of the sentencing judge. MPC decisions are rendered after considering statutorily required criteria. The law, however, does not specify how MPC should weigh these factors. And as you see on the screen, as Ryan mentioned, there are many. Circumstances of the crime, like we mentioned, victim impact, risk of reoffending, compliance with the case plan is really big. But like I said, it doesn't always weigh those factors equally. For example, we have here one of the many that we reviewed cases. This case showed that two factors were heavily considered: circumstances of the crime and victim impact. What you see on the right side is a parole recommendation decision form. We all get them when we go up for parole. This is something that we sign off on. The hearing examiner or commissioner sign off, and this is basically their decision. And, you know, it's redacted a bit, but as you see on the right panel, there are some rehearing recommendations that they're making. At the bottom, there are some handwritten comments that the commissioner makes. So we also got along with this form the parole hearing transcript, which was 45 pages long. Out of a 45-page long transcript, 27 of those pages focus exclusively on the details of the crime. 10 pages indicated a focus on non-criteria items, nothing that's in the parole criteria. Commissioner's disapproval of child custody arrangement made by the petitioner at the time of her arrest and incarceration that has nothing to do with anything. News articles and or material found on the internet in reference to the case, and opinions of the sentencing judge, opinions of appellate judges. Only 2.5, that's 2.5 pages, indicated the examiner's questions pertaining to rehabilitative programming, current mental health, and program participation. In my case, decision-making was not made objectively, considering my future risk to the community, but commissioners took a more balanced approach, considering all the criteria on the list at my hearing, and as a result, my outcome was far different than the previous example. So my point is, you know, this best practice recommendation should be adopted, of course, but it's only as good as the hearing examiner or the commissioner, because it's useless if it's not uniformly utilized by all MPC staff. And I would just wanted to, you know, backtrack briefly on the comments on this form. This individual had no infractions, was in mental health treatment, continue their education, maintain a job, the same job for decades, but the commentary at the bottom just says they committed a horrendous murder. They need mental health. But when we read the transcripts, there are probably, 2 or 3 pages about their mental health treatment. So those two things don't always parallel, what actually happens in the hearing and what ends up in the commentary. So, you know, in closing, as someone who is directly impacted, I think it's important that these practices be adopted, but they must be adopted uniformly by all staff. And I'll pass it on to Mr. Willie at that. Thank you.
Good afternoon, everyone. I'm a directly impacted person by the parole procedures. I'm a formerly incarcerated person who was incarcerated for 30 years, 110 days on a life plus 30-year sentence. I was 16 years old at the time of my offense, and during this time, entering into the institution, you were told that in 12 and a half years, you will be eligible for parole. They don't give you what kind of programs you should be taking, any type of roadmap to help you become eligible for parole. And during this time, I'm sure you all aware that then Governor Glenn Denning, I believe, said that life was life. So no one who had a life sentence was eligible for parole, well, would not be given parole. So this time, no one, or very few of us with a life sentence even inquired about a parole hearing. And it wasn't until 20 years later I inquired about a parole hearing, 21 years later, 2011 or 12, I believe. So during this whole time, I never went for parole because of what we were already told, that no one was getting parole or granted parole regardless of what we did in prison. And then I reached out to the parole commissioner because there was a disconnect between the parole commissioner and the Department of Public Safety and Corrections. And when I mean this is that we were sent to an institution that had no programming, which is North Branch Correctional Institution. I'm pretty sure you all are aware of this institution. There's no programming. There's no cognitive programming. There's no vocational trades or anything. So we're told that the parole commission requires certain programming, trades, education to even be eligible for parole. So if you're sent into this institution that has none of these programs, and you see the parole commission and they ask you, what have you been doing for the last 20 years? You have nothing to show for it. So my first parole hearing was a formality. And it was only I only wanted to go so that I can get a lesser security and possibly get some vocational training and cognitive groups. So I went for parole and was denied. They told me that they will receive me again in 5 years. I was allowed to transfer out of this maximum security prison to a medium security prison, which allowed me to get cognitive groups, programming, and so forth. But again, these institutions did not allow those who were serving life sentences to enter certain programs because they were only afforded to people who had shorter sentences. So this parole presumption and the goals of punishment, you can't meet the eligibility when you're sentenced to such a sentence. And also, the nature of the offense is always the primary reason on why you're being denied. The rules of the parole board in denying me, I went for parole 5 times throughout my 30 years. And each time, besides the first time, the statement was the subject presented himself well, he's remorseful, he has many programmings, but we don't feel that he's eligible for parole at this time. Until the third time, I was sent to the en banc, was allowed to take the risk assessment, which primarily dealt with static issues, the nature of the crime, what I did as a child. I was told that I was not commendable for parole because I was a 16-year-old who was addicted to drugs and the nature of the crime. When the whole 26 years at that time, I had no institutional record that evolved around any type of drugs or any drug history. But because of these things that I did as a child, I was told that I wasn't eligible for parole. And it wasn't until prison advocacy organizations got involved, some senators and delegates got involved, and they saw the atrocities that were taking place during my hearings, is that they started to pay attention to this. And then also the legislation changing the policy that the governor did not have a say-so in allowing, the last say-so in paroling lifers. I was then granted parole. And also I benefit from the JRA bill. So one of the things that we've seen in prison during my incarceration, that the elderly are suffering and being denied parole, even though they have life-debilitating sicknesses. I have 2 individuals, cases that I'm working on now, that they are doctors saying that they have 4 months to live. They went for parole and was denied, even to the point that they have court hearings that they can't travel to because the doctors say their health is so bad that they can't travel to these court hearings. So this is why I believe that there needs to be some type of change in these parole structures. Thank you.
I don't know if you guys caught what he said. I'm working on 2 cases right now. That's indicative across the board. Many of our partners who've had experience with the parole system, they're out doing excellent work right now. That didn't escape me when I heard them say, I'm working on 2 cases now.
Yes.
Because that's the case with all of our partners with lived experience. So I guess we excuse me, only have a few minutes left. We'd be happy to answer any questions about the report. But more importantly, I would like to offer up, if you guys would like to hear from our partners with lived experience, I think it's important to hear about, how parole could work, again, as a public safety tool. When you look at the work that Ms. Gwen Levi, Ms. Etta Myers, and Mr. Stanley Mitchell are doing right now, all that work is aimed at public safety. So again, I'll stop now, let you ask any questions about the report, but I would also ask you, encourage you to engage our partners with lived experience.
Excellent. Thank you very much. We'll take questions from the committee members. I see we have one already, so let's go with Senator West.
Thank you, Mr. Chair. It sounds like you've written a report on this, but I printed off your website earlier in the day a report that was introduced recently on recommendations for improving medical and geriatric parole, and I gather that's not the report that you're quoting from today. Do you have another report that you could provide to us?
Right, yeah, so it's forthcoming. We're finalizing it now. We've just gotten approval. We have to get approval from the Department of Public Safety and Correctional Services to make sure they read and reviewed, and because we were using their data, non-public data. We're hoping to have it out end of January, early February.
Okay, and that's basically the report you were orally quoting from today.
Yep.
Because I noticed that Mr. Wallington started out by talking about racial disparities in parole decision-making, but I didn't hear any further information about that presented orally. So I'm assuming that the written report would contain that sort of information?
Absolutely. So there is, and part of the reason why we did is a long report with a short period of time, and the racial disparity numbers are pretty consistent across all of the, we went through looking at hearings, at eligibility.
Can we have you stand up? So some members can see. Sorry about that. Yeah.
So the racial disparity numbers are pretty consistent across all of the different categories we were looking at, around similar to what we see in the prison system, about 70% black. So rather than just sort of going through it in a short period of time, Keith kind of gave the umbrella comments. But there is, in the actual report itself, we have all of those data spelled out.
Okay, so we'll get that information when we get the report.
Yes.
Okay. Thirdly, I was really taken by some of the information in the report I did read on the geriatric parole. I had no idea, for example, that in order to get geriatric parole, you must have committed a violent offense and subsequent offenses, so that it would not be available for anybody who had not committed subsequent offenses. And you could, as I think the last speaker said, you could be within days of your death and you still wouldn't qualify for parole because you hadn't committed subsequent offenses. This is the sort of information that I think is very useful.
Yeah, it's a
and
statutory
that would require a statutory change.
Correct.
Which is why we're here.
Yep.
Right? Okay. And then lastly, I wanted to talk about this idea of that parole should not be based on the original crimes. So let me just give you the hypothetical. A couple of years ago, we had a sniper in Maryland, and he shot a lot. He was a serial killer. He shot a lot of people who he'd never met. They were pumping gas or something, and he killed them, which showed to me a total absence of any moral capacity on his behalf. So if we're not going to consider, and let's assume he goes to jail, and he is a model prisoner, he doesn't commit any infractions, I can't imagine that we would ever agree to a system in which we would not pay any attention to what he had done when he committed his crimes, but let him out on parole down the road at the first time he's eligible for it, because we're not going to consider the underlying crime. Could you comment on that?
Sure. So the circumstances of the offense are obviously the core of the sentence itself that's handed down by the court. So they are a huge part, and the sentence itself, as I mentioned, will then ultimately dictate parole eligibility. Our argument is, and again, this reflects conversations we've had among experts in the field, is the belief that the circumstances of the offense, as Shakinan said, they're static, right? They can't be changed. Those are the factors that determine how long a sentence is. Then you have the parole system, which gives you an opportunity that once that person's incarcerated and they take advantage of whatever programming is available for them while they're incarcerated, that when they come up for a review. Eligibility for parole doesn't mean that you have a hearing, doesn't mean you're going to be granted. And if you have met all of those, you've met criteria to the satisfaction, you've changed whatever the issues are. Ideally, as I said, we want to have a really clear plan of these are the services, supports, treatment, programming, whatever that an individual needs. If he or she has met those when they're parole eligible, then they will go before the parole board, and those should be the factors that the parole commission should use to make a determination of release, without sort of saying, well, you've done all this stuff, but the crime itself was so horrific. Well, that was handled at the time of initial sentencing. That was considered at the time of initial sentencing.
This thing is, here we go. I understand where you're coming from, but wouldn't you agree that there is a difference between someone like Lloyd Malvo, who shot people serially without knowing who they were, just to kill them, on the one hand, and some guy who's in the car, he's the getaway driver in the car, and the policeman comes up and says, get out of the car, and an impulsive, rash decision, a split-second decision with no forethought at all, he guns it and happens to kill the policeman as he's trying to get away. I mean, I can see a dramatic difference between those two individuals. They both could go to jail for the same period of time. They both could be eligible for parole at the same time. Wouldn't you agree that the people considering whether or not to grant parole ought to take into account the difference between the two crimes?
So I would not, and the reason why is I think that while they're incarcerated, the sentence they're given and the time they're incarcerated should address whatever the particular needs are. So whether it's Lloyd Malvo and his issues versus somebody else that was more spur of the moment and emotional, then I would hope that while that person was incarcerated, that whatever those particular needs were, if it's mental health treatment, if there are some sort of personality disorders that need to be addressed, that those would be addressed while they're incarcerated. And if they are and have met to the satisfaction of the individuals who are providing the treatment, and he's said that, you know, this is the way he was when he was 18, and in the case of Lloyd Malvo, I believe younger than that, and now he's 40, and he's no longer represents that threat. I mean, that I think is the core issue right here, is that, you know, it gets back to this, which I'm sure you've heard, right? We all are more than the worst thing that we've done, and for individuals who've done something and then shown that they have transitioned, that they have changed, that they've transformed, that regardless of the details, I do believe that they should have an opportunity to have all of that sort of experience incarcerated be the primary factors that are used to determine whether or not they should be released.
Could I add something to that also, just to reiterate what Ryan said, that's handled in the courts. There's typically a sentencing difference between your Malvos and some kid that sped off during a police stop. People like Malvo, they have extreme sentences. And we can't really use him as an example because he probably, you know, would never get out. But in cases where there are, you know, multiple deaths in there, the sentencing judge usually sentences them accordingly. So there would be a big difference between how much time he would serve and how much time a person who sped off at during an arrest or an attempted arrest would serve.
And also, just lastly, their parole eligibility could potentially be different as well. What percentage of the sentence? So there are other factors above and beyond what the commission itself is determining.
Thank you.
Thank you, Mr. Chair. Thank you all for coming out and testifying on this important issue. I just wanted to ask a few questions. It's probably best for you, Mr. King, to respond. When we were looking at, I was fortunate enough to be able to review some of this. I think it would have been really helpful if everybody had had a copy in advance to be able to really properly prepare and have your questions. But did the Justice Policy Institute request the statistical information I heard you say earlier about the statistical information regarding race was something that you had brought up. And you were saying that, I guess in the study, it shows that there was a disparity in the release rates gauged on race, correct?
Yes, across all, which is
Okay.
similar to the disparity in the prison
So,
population.
but did the study determine that the parole commission itself, that the decisions to deny parole appeared to show some sort of race bias in that, just by that matter itself?
Right, no, we did not, we didn't do sort of an empirical test or anything along those lines. We're just purely descriptive, so we wouldn't be able to tell what the, whether race was playing it versus the underlying characteristics.
So there would be
of race.
there's no inference or anything of any type of misconduct or anything like that that's being implied. It's just that the race numbers, statistically speaking, and we both know statistics can kind of
Right.
be, fluctuate, that was how that was determined.
Right, and as I said, the prison population is roughly 70% black.
Yeah.
And the parole numbers across are all about 70%. So I think if we saw something where, like, the parole grant rates were, very, very low for black individuals, you would question it more. But I think both, and we actually looked in grant rates, and those are in the report as well, and we didn't really see anything that would suggest. It's more, as I think Keith said in the introductory remarks, it just sort of reflects overall racial disparities in the system.
And then, did the study include any, like, I know you have some releasees here helping out, and I know that they're advocating for others, and that's outstanding. But did the study do any victim input, or did it do any victim consideration included for the study for these dispositions?
Sure. So that was a very big issue, was sort of wrestling with what is the role of the victim in a parole hearing. And one of the, I didn't discuss it here, but one of the what we've identified as the best practice is that that victims are entitled and should have a role in the parole process should they wish, but that their feedback, again, similar theme, should be exclusively sort of forward-looking. So, for example, if this person is released, I feel like my life would be in danger. Those sort of things are more germane than to just say, and what I think frequently happens is it's a revisiting of the circumstances of the offense.
So that's kind of what, following up on Senator West's question earlier when he was talking about, you don't want to revisit the crime, so to speak, every time you have a parole hearing. But did you find that the study showed that, generally speaking, the parole commissioners come in, they have a setting where they get to speak with the inmate or the incarcerated subject, and that on the first hearing, can we agree that it's important the first time out, because I believe that the structure is that you have to, it's the one time that they really have the opportunity to address the crime with the affected or the incarcerated subject, and then second and subsequent hearings, it's far less on crime and it's more on the rehabilitative process, the vocational programs they're taking advantage of, and how they've acclimated and are they a good product to be able to take the crime / analysis of potential recidivism and put them in versus a public safety threat.
Right. So, of course, and let me clarify, I'm not suggesting that, like, the circumstance of the offense are literally, like, verboten to be spoken in the process. What I'm talking about specifically is the role they play in determining the release decision by the Parole Commission. And I think what we've seen, not just the first time, but even in subsequent ones, and our other folks here can speak to it better than I can, that it's constantly back to the original offense. And so I'm not saying that you wouldn't discuss it, that you wouldn't talk about that you've changed and remorse. It's part of the conversation.
Sure.
But when the Parole Commission sits down and says, all right, here are the factors, that one shouldn't be, the one that ultimately is, well, you've done all this stuff, but. And
It shouldn't be the overbearing factor.
Right.
I agree. Okay.
Yeah.
I agree. All right. And thank you. Did the study take into account the institutional adjustment and or behaviors of the incarcerated person regards to disruptive or violent behaviors that may have been factored into the parole denials?
So we mentioned those are absolutely appropriate to be considered, right? And in fact, that's what we're arguing. Those are the types of things that the Parole Commission should be looking at. So, right, if an individual has gotten in a lot of trouble while they're incarcerated, engaged in violent activities while incarcerated, that's a whole different situation. They're a whole different risk to being released. That's relevant.
but did your study point out on any of these denials that these were mitigating
We didn't
factors?
go, I'm sorry, we
in
didn't
their
go through
denial?
in any individual cases in the study. It's all aggregate data. So we didn't go through like
Okay,
by case by case.
But that's an important element. Can we agree that that's an important element and factor in determining whether they're safe for reintegration?
100%. Yeah, and we say that in the report.
Okay.
Yeah.
And I'm sorry, Mr. Chairman, I have two more questions. The study references concerns regarding how Maryland, the Maryland Parole Commission is operating the list and numbers of recommendations. Can you address with the committee the current Maryland Parole Commission practices that you do find effective, and are some of the proposed recommendations that you're offering already in place?
Well, I think, and I'm probably not the best person to speak with this, but I know there is actually ongoing conversations around sort of the compassionate release piece with the Parole Commission, particularly around sort of potentially the criteria that are used for determining individuals. So that I think that's an area where there has been some progress, for sure.
Yeah, and I mean, you guys have already had that, but okay. In your other report,
Right. Well, that's still in
this
report because it's
so you included some of that because some of that I saw
Yeah.
in your other data as well.
correct.
And then now on your report that we don't have a copy of yet, on page 18, it makes it very specific that there's a presumptive reference regarding parole commissioners with prior law enforcement experience, often wanted to relitigate the case. And I'll quote it. It says, because most commissioners are former law enforcement officers, there is little surprise about how they often use discretion to consider the factors for parole review. This often means relitigating the circumstances of the underlying offense and weighing these static factors more heavily than personal growth, program completion, and disciplinary record while incarcerated. That's from page 18 of your report. Is this assumption based solely on the anecdotal quotes listed from a small portion of the incarcerated population that are listed throughout? Is the assumption, and I mean, there's a couple points to this, but I don't know if you want to like do one at a time and answer, but is the assumption based on specific knowledge of the individual commissioners with law enforcement backgrounds?
No.
Is it possible that many of the commissioners with law enforcement backgrounds also have experience in other areas that make them a much better benefit with their broader background in evaluating dynamic factors such as behavioral health experience, opioid issues, family members, associates with prior criminal justice history, or substance abuse history?
So it's based, that statement is based on sort of national research that has been done. So that's actually based on empirical research, that's sort of the role that the makeup of the Parole Commission plays in grant rates. So that's where we've drawn that from. So it's not based on quotes or anecdotal evidence, but it's not based on data we've done specifically in Maryland. It's sort of a broader observation from conversations in the field. But yeah, nobody's suggesting that somebody with a law enforcement background is wholly unqualified, but that by and large having a bias of individuals or a disproportionate number of individuals that are coming from a law enforcement background, and this is again sort of a research that we've seen across the country, tends to be lead to lower grant rates and much more of an emphasis and conversation around the underlying circumstances of the offense.
Okay, well, I really appreciate it. This is a great start to this. I'm really excited to see how this unfolds because I am one that, you know, as a career police officer, I've put almost 30 years into it. I would love to see a lot more of these vocational opportunities coming in, and I don't like it. You know, I have family members that have been incarcerated, extended family members, and I want to make sure that, you know, I've heard from them their concerns, and when we're talking about where you end up and what vocational opportunities you get, I understand those concerns, and I look to continue this discussion to expand those opportunities so that we then can delve a little further in to a less recidivism.
Right. Yeah. Absolutely. No. And I appreciate your questions. And
Thanks.
it's great to this is what this report and briefing was about. Was just again let's get this conversation going.
Thank you.
No, that was excellent. Thank you very much, Senator Folden. Additional questions from the committee? going twice. All right.
Thank you so much, Mr. Chair, Mr. Vice Chair, members of the committee. We are happy to follow up with any information via email and look forward to coming back before you.
Excellent. Thank you very much. We'd love to have the top lines from the report. That's great. Thank you very much. All right. So the next, we got one more. We've got the Department of Public Safety and Correctional Services. We've got 3 panelists. So the acting secretary, Ms. Schruggs, is not here. So we will hear from Mr. Blumberg. It's the chair of the Maryland Parole Commission. Martha Danner, the director of the Division of Parole and Probation, and Angelina Gorino, director of the Office of Data Development. Welcome. Who wants to go first?
Oh, I guess I will.
All right. Would you like to come to the podium? Or?
Oh, I guess I will.
We appreciate you. Thank you.
Good afternoon. I'm Commissioner David Blumberg, Chairman of the Maryland Parole Commission. Many of you are familiar with me. Some of you I have personal relationships with that I certainly have enjoyed. And I'd be remiss, actually. It's good to see you, Chairman. I tamed it down a little bit for you today. Didn't want to scare anybody, so trying to fit in, you know. Mike McKay, it's good to see you. You're lucky to have him on your committee. This man walks the walk as far as reentry. Takes people, high-profile people, violent past, puts them to work in a small community where everyone knows, and he does it with no fanfare and no credit. Pleasure to see him here. Chris West, I've known you over 50 years. I still look the same, and you don't. You're a wonderful person. Mr. Sidnor, I know your dad. It's a credit to our department. Public safety is. Absolutely. Joe Carter? Present. My state senator. Known her for an awful long time, too. And I enjoy our relationship and our conversations. So I'm here today to talk about parole in Maryland. And I am scripted. And I think the 11 secretaries that I serve under are always worried that I go off the script. But there's no secretary here today. But Assistant Secretary Scruggs couldn't be here, but she apologizes. And I'm glad to have this opportunity. Justice Policy, appreciative of their work. I respect their opinion. Some things we agree on, some we probably don't. But I'm glad they're interested in the process, because that's important. First, I want to talk about 85%. Now, I'm going to need help with this. Yeah, I'm. Do you push the?
Just push down. Or click. Oh. It doesn't press. Oh, where to go? So you just have to use this to just scroll down. You can scroll back up.
Oh, okay.
Or, yeah, I don't know. Yeah, the keyboard. So just use the mouse to scroll down. Does that make sense?
Who's that short man with the loud jacket? Was that me?
That's you.
Oh, for God's sake. I wish I hadn't asked for this, but, all right, well,
Scroll down, sorry.
oh, scroll down.
Yeah, with the mouse.
Is it clicked in here? There we go. I'll switch sides. You got it.
Okay. First, I would like to recognize that 85% of jurisdictions have parole authorities who are appointed by governors and serve a 5-year term. In contrast, Maryland parole authorities are actually appointed not by the governor but by the secretary with approval by the governor, and we serve 6-year terms. Currently, I'm in my 20th year on the commission as chairman. I'm the longest-serving chairman in the history of the Maryland Parole Commission and the longest-serving chairman of any releasing authority in the country.
Scroll down once.
The criteria for an individual to become a commissioner or hearing examiner includes that each commissioner or hearing examiner is appointed regardless of political affiliation, is a resident of Maryland, and has training and experience in law, sociology, psychology, psychiatry, education, social work, or criminology. And as mentioned by Justice Policy Institute, statutorily we determine release decisions, people serving 6 months or more in any state or any local facility in Maryland. And our authorities covered both in the Correctional Services article and also in Title 12 of COMAR. Currently, we have 10 commissioners, 9 hearing examiners, and 54 staff who serve a number of units, include parole and executive clemency, parole services, post-release, support services, victim services, and institutional parole associates. The Commission may grant parole through 3 mechanisms. Parole is discretionary and conditional. And for this purposes, IP is an incarcerated person. And if we parole someone, it means that they're getting on discretionarily, not by credits. Everybody earns credits generally unless you have a sentence that does not allow you to earn credits by the type of offense that you're serving. And upon this release, you're under supervision of a Division of Parole and Probation agent until the end of the term. Medical parole, people have to be chronically debilitated or incapacitated to such an extent that they do not present a danger to themselves or others. And there's actually no parole eligibility requirement as far as the amount of time served before people are considered for medical parole. Geriatric parole. And Chris West is right. There are currently 7 people, we believe, in the state of Maryland who would qualify under this. 14101 used to be 643B, mandatory sentences for crime of violence, subsequent offenders. Very few judges use this mechanism to sentence people. Last year we worked hard with this committee. I'm sorry, Senator Hedelman is not here. Really enjoyed working with her, and we had a bill that we hoped would pass. It did not pass, which would have expanded geriatric parole and medical parole. Currently, medical parole still must go through the governor for life sentences. Starting January 7th of this past year, the Parole Commission now determines parole eligibility, not only as far as setting hearings, but also parole release for people serving life sentences or sentences that have been suspended, with the suspended portion being a portion of the life sentence. In 2022, we had 5,922 parole hearings between state and locals. 959 were granted parole, 17 medical paroles granted, 19 pardons, that's from the governor's office, 124 open parole hearings conducted, 1,407 warrants issued, which is a tremendous decrease. It has to do primarily with less reports from the Division of Parole and Probation, and of course the Justice Reinvestment Act. And we had 5,086 letters sent to victims and representatives, and 5,114 agents' reports processed. Page 8 of the JPI report states that an incarcerated person petitions for parole at 15 years. In fact, incarcerated persons do not petition for parole. Instead, they are automatically scheduled for a hearing as soon as they become eligible. And that's important. You have to actually waive a parole hearing not to have one. Very few people in the Division of Correction ever waive a parole hearing. In locals, it is far more likely because with shorter sentences, they don't want to have supervision after release. The parole process actually begins months before the hearings and involves many different components. And you can see that's a flow chart, but the process begins automatically based on hearing eligibility calculations that are determined by sentence type and schedules that are set proactively by the Parole Commission. The parole hearing process requires parole commissioners to conduct hearings for incarcerated individuals who are serving a life sentence when there was a loss of life, or at an open hearing, which is opened by victims. That's statutory. Hearing examiners hear all other cases. At times, parole commissioners may act as hearing officers, allowing them to hear other cases. Hearings are conducted at least twice monthly among all state correctional facilities, as often as necessary in the locals. On page 11, Justice Policy Institute states that the Parole Commission must notify individuals within 15 days of the date of their hearing. This practice was reflected in COMAR, and the MPC makes every effort to notify an individual in a timely manner. We could do better. I agree with them. We could do better. Case managers are overworked, something we should improve on. And I am aware of it, and it will get better. As slide 13 indicates, family members and attorneys are not able to participate during a regular parole hearing. However, parole commissioners make themselves available to meet with family members and attorneys. We have office appointments every Tuesday morning at our commission offices. We also, during COVID, we came to work every day. We did hearings. We didn't stop at all. Didn't miss any hearings while the courts were closed. It's one of the reasons our numbers might have taken a slight dip in number of hearings held and releases, but in fairness to the commission, we still heard everyone that was eligible. It is true that the people we're hearing now generally have longer sentences with violent crimes, which pushes eligibility back. And by pushing eligibility back, it means that we'll have fewer hearings because less people are becoming eligible. Open parole hearings, which are requested by the victim or their representatives, do allow for family members and attorneys to attend. It also allows the incarcerated persons to have representatives at the hearing as well. Slide 14. everyone actually gets a risk assessment. The public safety risk assessment is evidence-based. It was validated in Maryland. It has both static and dynamic factors. And it's for people that are not serving life sentences. And it's administered by the hearing officer before a hearing. And much like a judge, we have guidelines as far as low, moderate, and high, and then months as far as a sentence structure, and then months that are plugged in as far as what the guidelines would be for a release. And these are advisory, they're not mandatory, but we look at these guidelines as something that we should consider in making decisions. The HCR 20, Maryland is one of only 8 states that uses it. We deserve credit. Most states use the VRAG exclusively, Violence Risk Appraisal Guide. Only static factors are considered. So that means, as Justice Policy pointed out, that if someone is scoring a VRAG, the day you walk in, the score probably should be the same 20 or 25 years later. We didn't think that that was a very good system. The HCR 20, even though it's only good for 1 year, while a VRAG, according to psychologists, has a life of 3 years, the HCR 20 uses static and dynamic factors and does include progress during incarceration. The Justice Policy Institute noted a 2-year backlog for the HCR 20. In fact, prior to COVID, the backlog was only 8 months. That's not great. When I started in 2003, the backlog was over 3 years. During the pandemic, virtual parole hearings were being conducted, but due to COVID protocols, psychological services were not able to enter the institutions to complete the assessments, contributing to the backlog. Now we're back in the institutions. I'm also in the process, January 17th, of hiring another psychologist to cut into this backlog. The governor's office required that we have a risk assessment done on every individual that came in front of the Parole Commission for consideration. However, the Parole Commission now has decided that any 2 commissioners can take any case forward with or without a risk assessment. Now, sometimes a risk assessment is helpful to commissioners in determining things that otherwise they might not be aware of. But sometimes, especially with someone who is older, you might wonder if a risk assessment would be as pertinent, especially if someone has been in a great period of time. So that is a change that has happened just within the past year, since the Parole Commission now has control over life cases, all except medical parole, which still must go through the governor. Okay, let me talk about slide 15. Hearing examiners may make a recommendation to grant or deny parole. At the conclusion of the hearing, the examiner informs the individual of their recommendation. The recommendation is submitted to the parole commissioners, and the individual is advised of the outcome within 21 days of the hearing. The individual may appeal the result of the hearing within 5 days of receiving that decision. Parole rank rates since 2016 can be seen on this chart. When examined by the most serious offense category, the discretion of the parole board can be seen more clearly. Grant rates are highest among individuals serving drug offenses, followed by property offenses. Parole grant rates were lowest for individuals serving sentences for crimes against persons, but holds and rehearings were much higher in this group than in non-person-based crimes. So when people are saying they're refused parole, refusal means you won't be heard again. But the word deny parole should not indicate a rehearing is not a denial. It means that we will see you again in a specified period of time and request that you do certain programming if available. And we understand that some institutions offer different programs. Some offer more, some offer less. But we do give certain criteria that we'd like to see be considered for rehearings. Also, I want to mention one thing about relitigating cases. What we have when we come to a table to an initial parole hearing is the state's version or the indictment. So we're getting exactly one side of the story. So every incarcerated person that I've ever had come in front of me, and I've had thousands, really want to tell us their side of the story, which they're entitled to do. If you call that relitigating or rehearing the case, then I suppose to a certain extent we do that because if we just went by the state's version and said everything in there is correct and we're just using this as our Bible, and if you disagree with this, then obviously you're not telling us the truth. That's not fair. So we need to find out from the person in front of us at an initial hearing exactly what they say occurred. Sometimes they'll agree exactly with the state's version because they'll read that to them, or the pre-sentence investigation. Other times they'll say that's not at all correct. And we listen to both sides. And we know oftentimes the truth, as in many things, is somewhere perhaps in the middle. But we do need to hear from the person in front of us their version of the events. Public order offenses, which include many weapon offenses, had the highest proportion of refusals and relatively low grant rates compared to other non-prison-based sentences. Parole supervision is provided by agents within the Division of Parole and Probation. Actually, people under parole are only 9% of the active supervision caseload under the Division of Parole and Probation. And Martha Danner, who's the Director of Parole and Probation, will talk to you now about the rules and responsibilities of parolees and other people under the supervision. But we're especially proud of our recidivism rate for parolees compared to any other type of release, compared to mandatory release or court release, any other type of release. The recidivism rate is far higher than people that are discretionarily paroled. So the decisions we're making are good ones. The last thing I want to leave you with before I sit down, and this is not my remarks, it's interesting to hear Justice Policy talk, and I understand how they feel about the commission of a crime and what importance it should have in front of the Parole Commission. We feel that it takes its most importance at an initial hearing with decreasing importance at every hearing afterwards. Currently, we are being sued by a victims group who says to us that we need to consider the nature and circumstances of the offense at the same level at the first hearing as at the 8th or 10th hearing. So while I understand how the Justice Policy Institute feels on their end, I want the committee to understand the pressure we're also getting from the other end, feeling that, in fact, we are discounting victims by not taking into account, in their words, the event that has shaped their life more than any other. So we're doing, I think, a very good job trying to balance a lot of factors. We have a lot of statutory things that we consider. I'm proud of the commission. We've come leaps and bounds in the 20 years that I've been there. And it's not necessarily at all because of me. But we have evidence-based practices. We use risk assessments. We have psychological evaluations. The commissioners work hard. The hearing examiners work hard. And I'm proud of the Maryland Parole Commission. I was president of the Association of Paroling Internationals from 2018 to 2022. And Maryland may have some issues, but when I contrast this to not only many states but many countries, we have a lot to be proud of with our paroling system in this state. So let me turn it over to Director Danner. Thank you for your indulgence and personal observations about the membership. And thank you, Chairman.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the Judicial Proceedings Committee. My name is Martha Danner, and I am the Director of the Division of Parole and Probation. And I will provide an overview of community supervision for those individuals released on parole. Currently, there are 3,699 individuals under parole supervision throughout the state of Maryland. They are required to abide by the terms and conditions set by the Maryland Parole Commission. DPP agents develop an individualized case plan to determine the level of supervision, which includes a validated risk assessment. Agents work with community partners to connect individuals with support, including substance abuse services, mental health programs, specialty courts, and victim services. When an individual is not in compliance with the condition of their supervision, the agent works with the Parole Commission to have additional conditions imposed or to request a revocation. Non-payment of fees is a technical violation. However, if it is the sole violation, DPP does not report it as a technical violation. If at the end of supervision there are outstanding fees remain, they are reported to the Central Collection Unit. Since 2017, parole supervision cases have been closed satisfactorily at a rate that exceeds the national average, and technical revocations have decreased. This is due in part to the reforms enacted by Maryland's Justice Reinvestment Act, which created graduated non-custodial sanctions for low-risk technical violations and set shorter revocation sanctions. Now I would like to introduce our Executive Director, Angelina Garino, for Office of Data Development to discuss the statistics that demonstrates the success of our parole supervision.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the committee. In response,
Do you need any help with that?
Thank you, Mr. Chairman. I also would like to extend my gratitude for the collaboration that we've enjoyed with the Justice Policy Institute. In response to their data request, we were able to develop new methods to examine parole data and extract outcomes out of our data system for the first time since it came on board in 2015. The resulting trend analysis, alongside the department's work on recidivism measurement, reveals parole outcomes that are consistent with our expectations and have predominantly positive outcomes. As you can see here, an examination of all hearings and outcomes since 2016 identified paroles granted as the most common outcome, followed by refusal. However, there's a wide breadth of other outcomes that are not refusals and provide the opportunity for parole to be reconsidered and later granted. Echoing what Mr. Wallington previously spoke to, an examination of the demographics of DPSCS populations at multiple decision points of the parole process reveal a process that is consistent across demographics and is most impacted by the existing demographics and sentencing trends by the Maryland judiciary. The JPI report speaks to a racial disparity, but it is important to note that the department has no control over who is sentenced or their sentence length and the specifics that may dictate eligibility for parole. Regardless of race, parole rates are equitable. The sole exception is women are overly represented amongst paroles granted, but this is often due to a lesser criminal history and shorter initial sentences. The discretion and evaluation of parole board members is geared towards correctly identifying those individuals who will be successful under continued supervision and who do not pose an undue risk to their communities. Examination of 4 3-year recidivism cohorts since 2016 confirms the discretion of the Parole Commission, as parolees have the lowest recidivism rate of initial release groups, including those released onto mandatory continued supervision post-release, who are in a most similar situation. You'll see those 2 lines in the dashed on your chart. The solid lines reflect release reasons that are not accompanied by subsequent community supervision. And you'll see that parole is significantly one of the lowest. Importantly, recidivism amongst this group largely involves technical violations, and only a small group returns within 3 years for a new offense. Of the candidates approved by the parole board for release, 70% of individuals do not return in a 3-year period for any reason. In closing, the Parole Commission and parole agents have benefited certainly from information about best practices that has been garnered from governing bodies, of which Chair Blumberg had representation, and we appreciate the opportunity to address the committee and are available for any questions.
Excellent. Thank you very much. Questions from the committee? Senator Folden.
Thank you, Mr. Chairman. Mr. Chairman, can I just ask you one question, sir? I just want to make sure I have my facts.
As long as I don't have to use the machine, I'm
corrected.
pretty
No,
good.
sir. No, sir.
Good.
And I do want to point out, I do want to thank you, because I think you've done things with the state for a couple weeks, over plus or minus 47 years-ish. Is that correct? In service to the state?
I actually am in the old pension system, so I'm not quite sure why I'm even here, but when I get that statement, it's actually my salary is less than my pension.
I was going to say.
So I don't. On that remark, I want to thank you all. Well, I didn't know you would know that.
Well, I tell everybody I'm a little smarter than I look. So, but
I won't comment on that. But go ahead,
I just wanted to ask you. So, I'm trying to figure out if my math is correct. So, hypothetically speaking, we have a person that is charged and convicted of first-degree murder. That person is parole eligible after 15 years, minus any credits they are allowed to accumulate. A person that is charged with second-degree murder is parole and convicted, is parole eligible only at half, 15 years, on a 30-year sentence. You following me so far, sir?
Yeah, I knew I'd get this question.
You know right where I'm going, right?
I know.
So isn't it possible that a person serving a life sentence with credits because they're not eligible for the second degree could get a hearing and be parole released prior to an individual with a 30-year second-degree murder sentence?
Yes.
Okay.
And actually, the sentence for second-degree murder was increased to 40 years.
Oh, so
it's
it'd be
possible.
20.
Right.
So it's a 20-year
we've had
minimum.
situations where people with first-degree murder charges have had 2 hearings before the person with a second-degree murder charge with a 40-year sentence has had a hearing.
And I appreciate your candor. I mean, that's a discussion, obviously, that we need to have here, but that's just an issue that I'm familiar with, and I think it's wholly silly that we have those guidelines set up that way.
I mean, our victim services people, unfortunately, have to answer these questions on, if not a daily, a weekly basis on why someone with a hearing of second-degree murder would have a later hearing than someone with, you know, you could have consecutive sentences for first-degree murder, but as long as it's 15 minus diminution of confinement credits,
Right.
generally you have your initial hearing in about 11 years. So the answer is yes.
Thank you, Mr. Chairman.
Well, thank you.
Thank you, Mr. Chairman. Mr. Blumberg,
Senator West asked me not to wear pink today. I'd like that on the record. Go ahead, Senator West.
thank you.
You're welcome.
So I was actually interested in the report that is available online dealing with medical and geriatric parole.
Okay.
Not so much the one that we haven't seen yet. And the information about geriatric parole really jumped out at me. The fact that in order to qualify, you have to have committed a violent offense and subsequent offenses That makes no sense at all, to be honest with you. How in the world, do you know how, have we made efforts to change this law over your tenure? And why hasn't this law ever been made more realistic?
Yes, last year there was an attempt to change it. It was not successful. Very few judges sentenced under that 14101 provision. Very few. And to be eligible for geriatric parole in the state of Maryland, that is a provision. We looked at the cases initially. We have paroled one person under that statute. Only one is applied under that statute. When I started, the number was 12. It's down to 7. Obviously, if somebody has been sentenced under this statute, they have a serious criminal record, but at the same time, with medical parole, they also generally, as they're older and have longer sentences and have been in a great deal of time, the odds are that they're also serving a capital offense. But yes, it's a statute that is very difficult for us to utilize because so few people fall under it.
So I gather last year Senator Heddleman had a bill, and I gather you worked with her on her bill.
Yep.
And we didn't pass it. Do you think it would be helpful if we took another look at that bill this year?
See, it used to be I'd have to look at the secretary and find out, or, you know, am I allowed to take a position on a bill? We did support it last year. Oh, yeah. Oh, so yeah. Well, let me look on this side of the room. If the bill comes before us, we'll be happy to consider it.
Great. That answers my question. Thank you very much.
I need an after-SAG card for that. That was flawless. All right, well, thank you all, and it's very good to see you, and I'm sure I'll see you a lot this session, but it's always good to see you all and wear something different next time.
Well, thank you very much. I do have a question. I know, or Senator Sitter, go ahead. I'll ask mine last. Go ahead, Senator Sitter.
Thank you. And this was just actually a staffing question.
Is it for me?
No, I think it's for the deputy.
Oh, good.
But good to see you. And good afternoon.
Good afternoon.
In looking at the statistics that were put forth and the number of individuals that were under supervision, I'm curious in terms of staffing and caseloads, where you see the department going. As Mr. Blumberg noted, my father just retired from your department last December. I had a cousin who retired a few years prior to that, and so I'm exposed to their conversations and their colleagues and things, and it's always been a thing that you always have too much. Your caseload is way beyond what one person can manage, and with everything that's going on in Baltimore City, I think there's been some talk about just the lack of individuals who are able to manage those caseloads, and it being a what's the word for it? It affecting negatively the kind of crime that may be happening in the city. So I'm curious, what kind of caseloads do you think are reasonable that probation officers should be having, and where do you see us going under this next administration?
Well, Senator, thank you for that question. I can tell you that our caseload sizes vary a little bit on acuity and risk level. We have, we try to keep our sex offenders caseload ratio at around 30 to 35. Our highest risk individuals, the same type of balance. Our overall average caseload is about 68, and that is in our JCR report. I was an agent, and typically when we do our caseload ratios, we are looking at active cases. As an agent, you count all your cases, but the active cases are basically what you're dealing with every day. We just started a drinking driving monitor academy the first Wednesday in January. We are starting a Parole and Probation Agent Academy in February. In fact, we have hired so many new parole and probation agents that we have to run 2 back-to-back academies. And we have steadily been hiring over the last 2 years. Just like the rest of the country, we've had a downturn with some hiring processes, right, and increased vacancies coming through COVID. But we are attacking that, and we are being successful. We also did an incentive to, if you are eligible for retirement, to stay on longer and to get a bonus. So we've been pretty pleased with that. We've had a lot of individuals that have decided to stay on for an additional 4 years.
Thank you.
You are welcome.
Thank you, Mr. Sidner. That's exactly where I was going. And I know it's a tough question and tough kind of space to delve into for you in particular, but you're here, so we've got to ask. So, obviously there were a lot of media attention, a lot of attention paid to staffing issues and the contribution that the perceived understaffing, or real, whatever it is, contributes to, obviously, the lack of supervision, and then, obviously, a connection was made there between that and certain rises in certain categories of crime. Now, you have here that less than 10% of parolees released with, you have to look at what's 10%, less than 10% recidivism rate within 3 years for the folks that have come through. Is that right?
Parole supervision.
That's right.
Yes.
So I'll just ask a little bit more directly. I mean, because I suspect a number of the discussions that we're going to have during this session deal with this, with staffing levels, and so the more direct question would be, is this a driving factor? Is this are there problems here? Because you're going to have some potential policy recommendations that come forward in the next couple of weeks. And I just want to have, you're here, if you're comfortable answering, and if you can, is there a direct nexus between your staffing levels and have you been able to draw those connections? And recidivism, because I'm looking at less than 10%, that looks pretty good to me. I mean, that sounds pretty good, but,
Is this on? If I may speak, certainly not to the staffing, which is under Director Danner's purview, but just from a statistical perspective, I don't know how many of you are familiar with our new DPP dashboard that's available on our website. It launched in November, and it breaks down not only caseloads by region, as well as the number of active cases per jurisdiction, and it breaks down outcomes. The slide that you see before you earlier that addresses outcomes of specifically parolees under supervision is actually drawn from that public information. And I direct it partially because it speaks to exactly this question. Caseloads in the Baltimore metro region are the lowest across our system, and overall our average caseloads are below the national average, both as a whole as well as when looking at the caseloads recommended for specialty caseloads and respectively for certain risk levels, as Director Danner spoke to. As from a data perspective, there is no nexus in our data between the caseloads in Baltimore and the outcomes in Baltimore being deleterious, especially compared to the rest of the state. If that were the case, you would expect the outcomes to get worse where caseloads were higher, and that's not what we're seeing. Specific, especially to the parole population, they have larger compliant case closures than other populations under supervision. So to answer that question more finely, I do not believe that there's any support in the data between the caseloads in Baltimore contributing to any recidivism amongst the parolee population, and the parolee population is more successful under community supervision than under other populations.
I really, really appreciate that, because I think that's definitely going to be an issue that we're going to deal with in this coming weeks. And I was wondering why that wasn't part of a package of recommendations, that we discussed earlier. And so maybe that's why. Look, I appreciate this. Thank you very much. This is we've done a number of reforms here, starting from JRA, like Justice Reinvestment, to JRA, the Juvenile Restoration Act, and we've slowly merged from the nonviolent to now we're kind of in the hard. Part of the more violent crimes, it's just much more difficult conversations to have in terms of reform. And so the information that Justice Policy Institute and you all have provided, I think, will help us tremendously as we move forward and have these tough discussions and we continue our reform efforts. So just want to say thank you very much for your time and your responsiveness. And unless there are any other questions, that'll conclude our briefings.
Thank you.
Excellent. Thank you very much.